they're all lawyers, you can talk for 2 minutes.
The problem is always up to walk.
Probably what we want to do is somehow draw lots. Okay.
It's not bad.
Okay, so this will be open, and then every question we're going to rotate, so it's a different order. Thank you. Okay. So you got to tell Chase like
Write down your name. Ooh. Right?
Agree. So it's going to be David, you, and then me. You ready?
You saving a seat? Get out with my fingers. All right, welcome everybody. Thank you for being here. Let's get started. Have your attention, please. Thank you. All right, welcome to the debate for the candidates for Utah County Attorney. So my name is Nelson Abbott. I'll be a co-moderator at this debate. And our other co-moderator is right here, Chase Atchison. So what we're going to do first is we're going to, first we'll start with a pledge and a prayer. And some of you may have been handed out cards to put down questions that you wanted to ask. After the pledge and the prayer, I've got some just blank 3x5 cards. If you have other questions that you think we should be asking, I'm going to hand those out while Chase is talking, and you can write questions down here, and then we'll look at those, and we may or may not ask them at the end of the day. But anyways, so our prayer today will be offered by Greg Adams. He's the precinct chair, PG 314.
Our Father in heaven, we are grateful to be gathered today as delegates, as fellow citizens, and as children of thee. Father, we're so grateful to live in a nation where we have the freedoms to gather as we do, to vet out candidates that we best and hope feel will uphold the standards that this nation is founded on. Father, help us to decide on candidates that will consider thee before making policies and decisions that affect our lives. Father, we're, again, grateful. We ask that those that are here tonight, that they will be able to be articulate and clear, and that the questions we ask will be able to help us to understand who will be the best attorney for this county. Again, Father, we thank thee. We say this in Jesus Christ. Amen.
Amen.
Okay, and then our pledge tonight will be offered by Bob Bates, and I just got to say something. He is a World War II veteran, which is amazing. Sadly, there's not a lot of them left, so it's great to have him here with us. When I walked in today, he opened the door and held it open for me, so he's still serving people after all these years, which is fantastic. So,
If you'll all stand, please. Place your hand over your heart and repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. God bless us.
Thank you so much, Bob and Greg. My name is Chase Atchison. Again, I'm here co-hosting with Nelson Abbott. We are so excited to be here with you this evening. This is an excellent opportunity to learn about the candidates who will be serving us as Utah County residents. First, we'd like to thank doTERRA for letting us use this lovely auditorium. It is a spectacular place. We are so happy. We also would like to thank Craig Thorne. Craig, where are you? He is still serving. Well, when Craig comes in, if he comes in the next minute, we'll give him a round of applause. But he is a Superman. He is the closest thing to a superhero that this county has. Craig has been serving so long, and he gives of himself so easily. The nearest emergency exits are behind you and to this side. Should there be an emergency, please stand up and exit in an orderly and calm manner, as calm as we can be if the building's on fire. And also restrooms, the closest restrooms are out that door, and you take a left, and I believe it's right between Kevin Stratton and Rod Mann's tables, so looks like they cornered a good spot in the market, as well as those are water fountains. And as we proceed, I ask that you hold your applause until the very end of this debate. We want to make sure that there are no major disturbances. As you can tell, our sound system is a little jumpy. Hopefully we'll be able to make it work. And as you see here, Nelson is passing out cards. You may also have passed put your questions on these cards. If you have not had an opportunity to write down a question, please raise your hand, and Nelson will try and get it to you. Okay. All right, let's talk about our format for this evening. Our candidates have drawn lots for their personal introductions, which will last 2 minutes. We have our timer here. What's your name again, timer? Seth. Seth is going to raise our cards. One is a 15-second warning, and the other is a time warning. If you don't stop, he will shout, stop. We've told him to be forceful. We've told him to lay down the law, given this is a county attorney debate, questions will either be 30 seconds long. In order, responses to those questions will be either 30 seconds or 1 minute. And Seth here will let us, he'll keep us on track. If one of you is mentioned directly in a response given by one of your competitors, you will have a 30-second rebuttal. Even if they don't say your name, but they're obviously talking about you, you'll get a rebuttal. So, following all the questions, we will have a 2-minute each closing statement. Then you can apply. Okay. Nelson, you want to kick us off?
Sure. Well, yeah. So let's start with the opening statements, obviously. So I think we drew cards.
Yeah,
So
first
who
is
would go
David.
first? Yes, David Levitt first, and then it was Jeff Gray, and then Adam Pomeroy. So.
Good evening. Thomas Jefferson said that a trial by jury is the only mechanism whereby the people can keep a government within the bounds of its own constitution. John Adams said that representative government and the trial by jury are the heart and lungs of our liberty. That without each of them, there is no mechanism whereby the people can avoid being worked like cattle, ridden like horses, and fed and clothed like swine and hounds. Why is that? For one reason. If you get rid of the checks and the balances in government, where the people don't decide the guilt or innocence of fellow citizens, then we live in a police state. We erode two important checks and balances. Now, those checks and balances existed in government until the Civil War, until we began to introduce something in the Civil War called a plea bargain. Plea bargains were a horrible thing back then, and everyone knew that they were a corrupt system. But they began to get popularity and grow because they were easier for everyone in the system. By the time we got to 1969, plea bargains still had not been determined to be legal, but we were plea bargaining 75% of our cases. Finally, the Supreme Court legalized plea bargains, and then it exploded. Prosecutors advocated their role in being a check against the police, on the one hand, and they usurped from the people the role of the jury at an exponential rate. By the year 2019, prosecutors were giving plea bargains in over 99% of cases in America and in Utah County, which means that 99% of the time, the government doesn't prove its case. That's why I'm running.
Before you begin, we have these questions that are going around. If you have not had your question picked up, please raise your hand and Nelson will get to it.
My name is, Jeff Gray, and I'm going to tell you a little bit about myself. So I grew up in Mapleton, Utah. My wife and I, we grow up in Mapleton, or we live in Mapleton. We've grown up now. So we live in Mapleton, Utah. And this county is very dear to me. I've been a prosecutor for 31 years. I started here in northern Utah County, small law firm, and we represented the northern Utah County cities. And that's where I got my start in prosecution. Now these cities, Alpine in particular, and Highland, they're a lot bigger than when I started. So I prosecuted misdemeanor crimes. I did that for 3 years, DUIs, domestic violence. And then I went to the Salt Lake City Prosecutor's Office. And at the Salt Lake City Prosecutor's Office, I continued to do the same, prosecuting misdemeanor crimes like domestic violence, DUI, and more that fortunately I don't think we have yet. And then I went to the Attorney General's office, and I prosecuted for 3 years as a trial prosecutor, prosecuting white-collar crime. And the last 24 years, I've been with the Criminal Appeals Division. And I've handled hundreds of cases in that. And I was actually thinking about retiring. Okay, I've been out there for 31 years. And I thought, but the more I heard about the current policies in the current
office, I knew that I needed to run and make a difference. I will prosecute. That's what we need to do, is prosecute crime. That is the job of the county attorney.
Good evening. My name is Adam Pomeroy, and I'm running for Utah County Attorney. I'm a current Deputy County Attorney, and I'm running for this office because from within, I see the need for change. I feel a keen sense of urgency to change the mistaken direction of our office. We are not doing right by victims. We are not doing right by law enforcement, and we are not doing right by offenders. And that is affecting you, your families, and our community. Well, our questions tonight are going to get into that, so I did want to take a moment to introduce myself to you. I'm an honors graduate of BYU Law School. After law school, I did a constitutional litigation fellowship at a place called Pacific Legal Foundation, formed by members of then Governor Rader's administration to protect individual rights from government overreach. And that's what I did. It was a wonderful experience getting to engage in lawsuits when the government has overstepped. I also wrote a law review article there that was cited last year by Justice Thomas of the United States Supreme Court. But after that fellowship ended, we had a decision to make. My wife and I said, this is where we want to raise our growing family, Utah County, her childhood home. So we came back. I started my own law firm doing criminal defense, where my main goal was to defend people, but make sure that their constitutional rights were vigorously defended. And then one day in court, the former chief deputy of this office said, Adam, there's an opening. Would you please apply? And I did. A few weeks later, I was sworn in, and I've been here ever since, and I have loved every minute of it. I love being a prosecutor. I've done almost everything you can do prosecutorial-wise in the office. I've been on the general felonies. I've done juvenile court, misdemeanor court, special victims unit, the major crimes assignment, which is a task force dedicated to narcotics and gangs. I've been on the screening team. And these experiences have taught me that we have a lot of work to do to make our system better. But we make it better by holding people accountable. I'm the only candidate with my unique set of experience, and I'm the only candidate with the current in-place relationships, perspective, and understanding to get the job done. Thank you.
Okay, now we're going to move into kind of even more rapid fire. I know that was pretty quick. 2 minutes isn't a lot of time to introduce yourself. But these are going to be really rapid fire because they're going to be 1 minute each, and we're going to have the candidates, at least for these first ones, we'll have each candidate answer. So the first question is, what is the proper role of an elected county attorney? And the order that we're going to go in is going to be Adam Pomeroy, David Levitt, and then Jeff Gray.
The proper role of the elected county attorney is to serve the people of the county that elected him. The proper role is to vigorously prosecute crimes, to work with law enforcement for your benefit, and to effectively manage the office. Thank you.
Go ahead this time.
The county attorney has two roles. Now, I have been a county attorney for 11 years. I've been a county attorney in Utah County for 4 years. I was a county attorney in a rural county for 8 years. As the elected prosecutor, you are the chief law enforcement official for the county on all criminal matters, and you are also the civil advisor to the county commission, the county sheriff, assessor, auditor, treasurer, clerk, reporter, etc. And so it requires balance. You have to be able to have not only prosecution understanding, but you also have to be able to have civil experience to be able to advise all of county government. Now, if you distill what I believe the responsibilities of the county attorney's office is, number one, the county attorney's office is to uphold your oath. The oath you swear is to uphold and defend the Constitution of the United States. It's not necessarily to work for the police, it's to work with the police, but to support the Constitution, and then to support the Constitution in representing the civil people of the country.
David is right. There's two roles. First, prosecution, and provide sound legal advice and representation to our county and county agencies. 80% of what the county attorney's office does is the prosecution side. And quite frankly, that's what's not happening right now. We're soft on crime, and we cannot be soft on crime. The proper role of the county attorney is to prosecute crime. Number one, prosecute crime. And what the evidence supports. It has to be what the evidence supports, not some notion of fairness as to less charges. So that's number one. Number two is to support and work with law enforcement. We are on the same team. We need to work together and provide training to law enforcement so they do their jobs and to uphold the law. And we'll talk about that later. But also to keep our communities safe.
Nelson, I think I get a rebuttal. I get 30 seconds on soft on crime.
I think that's right.
I prosecuted as a county attorney, statistically speaking, I've filed more sex crimes cases than my predecessors. That's a fact, and I'll send you all a mailer that shows the numbers. We've prosecuted homicide cases, sex abuse cases. We put people in jail who are violent and dangerous. To say that I'm soft on crime is a simple allegation that can't be supported by actual numerical facts, and it's just not true. The violent and dangerous, they go to prison, and we put them there. But those that are not violent, we have a different solution for them. That's not soft on crime, that's just smart.
Thank you very much. I meant to do this at the beginning, but those of you who are Utah County Republican delegates, please raise your hand. So these guys are going to be choosing between you three, so keep that in mind. Thank you so much. I appreciate the participation. All right. Now, I am not an attorney. I hope most of you aren't attorneys, but it's part of an attorney's, especially the county attorney's, responsibility to explain complex ideas in a way that we, the electorate, understand. So this is our question. How do you plan to reduce felon and misdemeanor recidivism in the county? The order that we're going to be answering that question is going to be Jeff, Adam, David.
We have to start by holding them accountable. That's how you reduce recidivism. You don't undercharge, but you hold them accountable. You don't do a pre-filing diversion program where they're never charged, all right, and then hope that they do well. You require accountability, all right? For the drug cases, the users, you get a guilty plea. You get a guilty plea, and then if they can hold the guilty plea in abeyance, all right, ask the court to do that. And then from there, if they comply, if they go through drug rehab and so forth, and stay clean, then it's dismissed. If not, you go straight to sentencing. We charge what the evidence supports, and that is not happening. There is no charging with respect to law enforcement if they're assaulted or interfering with arrest. I've talked to law enforcement, that's not happening. If you want to reduce recidivism, you hold the criminals accountable.
You admit it, you fix it, and you move on with life. So I teach my kids the principle that works for everyone. And Jeff is right, we are not holding people accountable in this county right now. We are consistently undercharging and refusing to enhance repeat offenders. You've seen the news article, felony death filings are down by half. That's what's going on. To hold people accountable, you must start by figuring out the crime that they did and charge appropriately. But then you individualize. You have to have the wisdom from being on the ground and understanding every program out there available and using the ones that help an individual not recidivate. You find the one that helps them get over their issues, whether that's drugs or mental health or just making stupid life choices. There are incredible programs out there that I know about because I'm doing this job and I'm in the courtroom every day. So once you found it and they've either not been amenable to fixing their problem and you have to send them to jail, or they fix their problem, you help both groups re-enter the community and move on with their lives. That will benefit all of us. Thank you.
Now, David gets 90 seconds because he was specifically called out.
Twice, don't I get another twice?
No.
It would be one thing, what they're talking about academically makes sense, right? Everyone should be held accountable. Swift sanctions very quickly. The problem with the system that the bureaucrats have designed is that it takes a year from charging to pleading to get a plea bargain, and then all the hope of a swift sanction is gone. They never learn their lesson, and the courts don't hold them accountable. Roughly 60 to 65% of criminals who violate their probation have no consequences given to them by the judge. So their method is to charge more, and more. Let's give them 10, 15, 20 different criminal charges, and nothing ever happens to them, ever. What my plan is a pre-filing diversion program. It gives a swift sentence, a swift sanction on the front end. You commit an offense on Friday, we're at your front step on Tuesday, we're giving you a swift sentence that week. And if you complete it and do so faithfully, then we don't make you a criminal. So that when you are later in life, you can get a job, you can get a house, you can have a life. It's about understanding that our punishments should be to change behavior and should be redemptive in nature, not punitive in nature. Because most of these people are nonviolent people, and that's what I'm doing. And by the way, all three members of the county commission agreed with this, funded $5 million for this program because they also agree with this program.
I believe we both get rebuttal.
So 30 seconds.
All right. I mean, he talked about sentence. There is no sentence. There is no charge in his pre-filing diversion program. There is no accountability. He talks about accountability. There is no accountability because there's no guilty plea. I will hold criminals accountable, and it's quite frankly, when they take responsibility by pleading guilty, that's the first step to reform, not by shoving it off and you're not facing anything.
Do you want to know the truth about the problem with the pre-filing diversion program? No judge, no defense attorney. You get a letter in the mail that says, I, as the county attorney, demand that you do this, or I prosecute you. We talk about checks and balances. Where are the checks and balances in that system? I'm the only one up here talking about being smart.
Please hold your applause for the end of the debate.
And we do need to be smart. And we do need to figure out who needs the hammer, but who needs the hand up. Thank you.
Again, please hold your applause for the end of the debate. All right. Here is a hot button topic. Please hold your applause for the end of the debate. So, yesterday, Governor Spencer Cox signed a bill into law, HB 257, which places limits on pre-filing diversion programs. This bill was sponsored by 2 Republican-elected Utah County representatives. So, what is your position on this pre-filing diversion, the limitations on pre-filing diversion programs? The order is going to be...
What kind of limitations does the bill provide?
I will let our gentlemen here just explain and put forward their positions. Our order is going to be David, Adam, Jeff.
HB 257 is emblematic of what's going on here. I am trying to restore the system the founders created, and the bureaucrats are trying to stop me. The bureaucrats want to have a cattle car experience of the criminal justice system where everyone, they want to charge, they want to convict, but they don't want to prove it, right? Do you think we ought to prove the allegations we make? Because the system that these guys want to do, you simply can't do it. That's why we never prove guilt. HB 257 was an effort on the part of former prosecutors from my office who actually believe that the government should punish without proving. Now, I can live with HB 257 because I worked with the legislatures to pare it down so that it does nothing to harm my program. So I'm fine with HB 257.
No one said no trials. No one said no proof. I'm not an advocate for that. I'm an advocate for doing it within the system. Pre-felon diversion is wrong. Post-felon diversion, we can have a conversation about that. Because then we ensure that people's rights are being respected, with a defense attorney advocating for them, and a judge checking us. I believe there is a role in our system for helping people. I believe there is a role for helping victims and offenders. But you cannot help them if you do not charge them. Now, regarding limitations, I think limitations are good. Limitations are great on prosecutors. You'll talk to your legislatures about why they put those limitations in place, but I suspect the answer will be is because they don't agree with what's been happening in the Utah County Attorney's Office.
I wholeheartedly support House Bill 257. The legislature has decided what the level of crime is, all right, whether it's a felony or a misdemeanor or whatever. And what Mr. Levitt has been doing is been taking felonies and reducing them to Class B misdemeanors so that they're now in justice court. So now they're facing less punishment than they otherwise would have if he would have filed as a felony as he should have. We need to charge what the evidence supports, period. And this notion that we don't have to prove it, of course we have to prove it. We have to prove every case. Everybody deserves a trial, if they want one. We have to prove it. Nobody's being denied. The only thing that's happening at this stage with this reduction of charges is the county attorney deciding that I don't agree with what the legislature decided on the penalty.
30 seconds rebuttal.
So you shoplift 3 times, that becomes a felony. Now, every time you shoplift, you can get 6 months in jail, which I wholeheartedly agree. Let's put him in jail for 6 months. We get that on a Class B misdemeanor. The problem is judges won't put you in jail for 6 months on anything for shoplifting. And so these guys say, let's make them felons every time they steal a bag of potato chips. Well, you know what? That's just bad policy. Because you make someone a felon, they're never going to get a job, they're never going to be able to have a place to live in the future, and it affects their entire life. What I'm proposing is let's just punish people for what they do. Let's give them 6 months in jail, but do it as a misdemeanor, not as a felony for something as stupid as a bag of chips.
Who gets the first rebuttal?
We got it.
We'll give them 15 seconds each. How about that?
Your names were not mentioned.
Nobody, that's a flat lie. A bag of chips for a felony, that's not the law. That's a flat out
Hold your applause to the end of the debate.
It's not just a bag of potato chips. It's tools from your garage. It's equipment from Home Depot. It is everything and anything going on in our communities of theft that is not being enhanced, including car theft. It is foolish to say, just put them in jail for 6 months, that will solve the problem. That is not smart. We need to be smart.
All right, so I've got 3 audience questions. I'm going to read all 3, and then I'm going to ask you to answer these kind of combined, because I think they all touch on each other, okay? So the first question, it's kind of long, but here we go. If Congress passes a law which is unconstitutional, but its nullity has not been formally acknowledged by a federal court, such as the U.S. Supreme Court, do you have a duty to enforce that law through prosecuting an alleged defendant, or a duty to ignore and thereby nullify that law? So that's the first question, okay? Second one, which kind of, in my mind at least, related, is there was a college student that ran a party for kids in 2020 during the height of the COVID panic. Would you pursue charges against the event organizer? Okay? And then the last one is, what determines your priority in prosecuting cases? So I guess the reason I see those as being related is the question being, what is your philosophy in determining what cases get prosecuted and what cases don't get prosecuted? And our order will be Adam Pomeroy, Jeff, and then David Levitt.
So that was the unconstitutional question, the late party question, and the philosophy question.
Yes, they're
All those
all
ones.
combined into one. So I'm
That's
just
like the
trying
rest
to
of the debate right there, Nelson.
maybe it's unrealistic to answer in 1 minute, but I'm hoping we can just kind of get your charging philosophies, if I can.
Sorry, say that again.
I'm just trying to get your charging philosophy.
Charging philosophy. Sorry, thanks for explaining.
Keep on going.
Keep on going. Charging philosophy. Look, my main philosophy that drives everything I do with criminal justice is to respect the individual rights and dignity of people and their moral agency, both for victims and for offenders and for everyone else in the community. So we need to make wise charging decisions that protect individual rights to life, liberty, and property. And we have a legislature who has told us how they want that done. So the first thing we do is we figure out when we get a police report, have they violated the law? If they violated the law, we figure out which law they violated. And then we look at that person as an individual to try to determine the best we can, and it's a hard job, to figure out whether any individualized adjustment needs to be made. And it's almost always going to be on the back end during sentencing, to figure out how we can help this person have accountability by admitting it, but then also how we can have this person fix it so they can move on, thereby benefiting the entire community and not having recidivism. Thank you. Well, Nelson kind of,
All right,
what do you want to do about that?
Give me an extra 30 seconds and we'll give everybody 90. How about it?
I don't believe in mandates. I just do not believe in mandates. I will advise the commission in my civil capacity to not implement a mask mandate. I would hope the sheriff would not enforce it, and I don't believe he would. But again, if we get a case, there's something going on there, and we have to look at it to figure out what's going on. It's probably going to be a criminal trespass or an assault. And we'll look for the real harm, not you wearing a mask. Thank you.
Next, yeah.
I will charge what the evidence supports, including enhancements. And I don't have this test of whether or not, okay, maybe this person, because of whatever circumstance, I'm not going to charge so many counts. We'll get to that after we charge. And after we've had the opportunity to actually talk to victims after all the charges have been filed, and then we'll talk. Okay, but it doesn't happen at the charging stage. At the charging stage, then you have the prosecutor making decisions without talking to victims and everything else. We need to charge what the evidence supports. And I will charge, including enhancements. And let's talk about the death penalty. I will pursue the death penalty in all appropriate cases. When the county attorney takes an oath, okay, to uphold the law, the state of Utah has determined and seen fit to have the death penalty. He violates that oath when he says that he will not pursue the death penalty in any case. That is violating the oath. We've talked about that. I will uphold the law. Now, I don't remember.
Throw you out, whoever you are.
Okay, how much, did you take?
20 seconds.
On mask mandates?
Lake Party.
Don't you charge them in the lake party during COVID? Or not?
Oh, okay, the party. First of all, it wasn't a crime. It was never a crime. All right, Utah County, the commission looked at that and it was never a crime. Of course I'm not going to charge it. I am against mask mandates.
All right, and then David, I think David was referred to specifically, so we'll give you 2 minutes. 2 minutes. 2 minutes.
My charging philosophy. The violence and dangerous need to go to prison. I prosecute the violent and the dangerous. And let's talk about the death penalty. I'm the only county attorney in 40 years to pursue the death penalty. I charged it. I pursued it. I spent $4 million of your money on a sentence that will never be carried out. And at the same time I did that, I was neglecting 17 other homicides, 235 sex cases, for a symbolic victory on a death sentence that will never be carried out. To me, you want to have an academic conversation on the death penalty? Let's have it, because I've charged it. Despite, nobody else here has done that. I have. But in a practical reality, life is different. Because I have 235 other victims to deal with and 17 other dead people to care for. And I'm spending your money for a sentence that will never be carried out. That is the ultimate bridge to nowhere. Now, I agree there are people that should die for their crimes, but it's not happening in a for any practical reason. And I have to run an office on the ground and take care of everybody. That's my charging philosophy. Charge the violent, the dangerous, put them in prison. The nonviolent, they're coming back to live among us. They need our help. And that's what I offer. That's what I'm doing. Thank you.
Make party. Make party.
How much time do I get?
5 seconds.
I'm not answering your question in 5 seconds. You're making me 30, I'll answer it.
All right. So,
The time has expired.
all right, we're trying to keep it fair. So, I mean, it's kind of a little arbitrary, I get it, because we're given time, but if we start expanding, we'll end up like a presidential debate where you can filibuster the most, so. All right. So, next question. Let's see. So this is, again, I'm going to combine 2 audience questions. Both dealing with the relationship between the county attorney's office and law enforcement. So the first question was, please describe your relationship with the Utah County Attorney or Sheriff's Office and other law enforcement agencies within Utah County. So obviously that was directed to the city and county attorney. I want to make it a little bit broader. And so the second question is, should the county attorney provide checks and balances on the county sheriff's department? So the question I guess I would pose is, what is the proper role or relationship between the county attorney's office and law enforcement? Okay, so we'll go a minute each, and the order will be Jeff Graves, David Levitt, and Adam Pollard.
Law enforcement and the prosecutors, we're on the same team. Okay, there's not supposed to be a tension between the 2 offices. We're on the same team. Law enforcement officers catch the bad guys, and we prosecute them. Now, one of the important things about that is we need to provide training to law enforcement. I've talked to Sheriff Smith. I've talked to other police chiefs. That training is not happening. That training is not happening. How can we expect law enforcement to do the job right when we're not teaching them and training them in the law? I'm the Search and Seizure Section Director for the Utah Attorney General's Office. I train officers regularly on what they can and cannot do. And one great thing about that is I also learn. I'm not on the front lines, all right? I'm not on the front lines. And the only way that I'm going to understand that is if I'm talking to law enforcement. I learn as much from them as they do from me.
David.
1 month into office, not far from here in American Fork, a member of the sheriff's office, 3 members of the sheriff's office had a handcuffed man on his stomach and were beating him on videotape. It's on
Ladies and gentlemen, do not say
It's on
that.
YouTube.
Don't do that.
You can see it. 3 days before that, one of those same deputies stopped an individual, took the barrel of his rifle and jammed it into the forehead of the person he had stopped, causing a gash on his forehead. And then a member of the sheriff's office took $2,500 of task force drug money and paid him off. And when the sheriff came to me and insisted that I should not investigate that, I thought that relationship is just not going to happen, because I am a check against the sheriff. When they do things wrong, I'll work with the police when they do things right, but I'm a check on them every time they do things wrong, and I always will be.
So much there, right? You know how you provide a proper check on the police? You earn their trust and respect. And I've done that every day for the last 7 years, earning the trust and respect of your local officers, speaking to your chiefs and your sheriffs. I've trained with officers. I've done trainings for them, and I've done their trainings. I did their Hell Week for SWAT. I've done their DUI A-Ride program. I've gone to a checkpoint. And I do that so I can understand them. But then we have to train them. I agree with that. We have to get out there and train them. And it's by working together that they see us and we see them, and we learn to trust. And then, based off that trust, we can have rational conversations to air differences, to talk about where we each can do better. When you can't even sit in the room anymore with your sheriff and your chiefs, that's a failure of leadership. That is not how we properly deal with our relationship with law enforcement. Sorry, what's that time card? Okay, thank you.
We'll give Mr. Levitt 30 seconds.
Folks, I don't have any problem working myself with police officers, but I'm holding them accountable, and they don't like that. I will always hold the police accountable when they do things wrong, and I'll work with them when they do things right. That's my job.
All right, our next question. As we know, the Special Victims Unit was disbanded. The question is a general question. What is your philosophy on having a Special Victims Unit in the County Attorney's Office? Oh yeah, excuse me. David, Jeff, Adam.
How much time do we have?
This is a minimum.
I got rid of Special Victims Unit because they weren't prosecuting the cases as they should be prosecuted, frankly. I only have 60 seconds. So I'll just cut to the chase. What I did was I added 3 more prosecutors from the 6 in the team to 9. I put 1 prosecutor that's sex crime trained in each courtroom, so that every courtroom has a sex crime trained prosecutor. And then I sent more prosecutors to specialized training. As things sit in my office today, 19 of my felony trial prosecutors have specialized training in sex crimes prosecution. If you look at the numbers, my office has prosecuted more sex crimes than my predecessor, both by percentage of cases coming in and by sheer numbers. Just because the bureaucratic way of doing it is to say we're going to have this Special Victims Unit doesn't mean it's the only way it can be done. And we're demonstrating that we can do it better.
There is no focus under the current administration on sex crimes, because we have no Special Victims Unit. We need a Special Victims Unit with expert attorneys that have the experience and training to prosecute these cases, and also work as a unit with the detectives that are investigating those cases. That's not happening, and there's been mistakes happening. And as far as the focus on sex crimes, we have a case where child sex abuse, this happened, this is in the news. Child sex abuse happened, and the current administration decided not to pursue the child sex abuse because the offender was no longer in the home. Okay, that is ridiculous. The offender should be punished, number one. And number two, the offender could reoffend again. We don't not prosecute simply because the offender is outside the home. And in many cases, they're not even charging enhancements.
I work with victims almost every day. I was on the Special Victims Unit when it got disbanded, and it was a mistake. It is national best practice for a reason, because the training and expertise required to deal with those specialized cases cannot easily be spread around an entire office. And what happened when that unit was disbanded is what Jeff Gray just told you about cases not being charged appropriately. There's more that's happening. Cases aren't being resolved properly. The inmates at the jail are literally keeping a list of case resolutions in special victims cases. And our unit, they shouldn't have to take accountability because some other prosecutor wouldn't force them to take accountability. There was a first-degree sodomy case of a child, which is a 25-year mandatory minimum, and one of the line attorneys that he gave it to pled it out to a 1 to 15-year non-mandatory prison term. That is not justice. And I have to tell you the real reason the Special Victims Unit was gotten rid of. From whom? I sat in the room with David Levin. I know he's going to get 30 seconds to respond. That's fine. I sat in the room. No, I got to get this one out. He told me. No, I got to tell you.
Ladies and gentlemen, the rules of this debate is that everybody gets an equal amount of time and rebuttal. If he wasn't able to provide the answer within he didn't provide his response did not fall within the time limit.
How about this? How about this? I'll give Adam Pomeroy my 30 seconds so that he can tell you what he says I said.
Thank you.
It's not what I say he said, it's what he said. And go ask any person on the Special Victims Unit for the truth about what happened. I was told to my face that the reason it was disbanded, after he promised law enforcement not to disband it, is because there were some attorneys on the unit who wouldn't follow his softer on crime sex policies towards people. Because he wanted a case that the line attorney wanted to go to prison to not have to go to prison, that he should work out molesting his grandchild with an LDS bishop. That's not how we prosecute sex cases. Sex cases against children should go to prison.
So the next question. So we've heard about plea bargains a little bit. I just want each one of you to talk for 1 minute, I guess, on what your philosophy is regarding plea bargains. And we'll go Adam Pomeroy, David Levitt, and then Jeff Gray.
Here's my philosophy. We do justice, and we do only that, and we do it all the time. Arbitrary numbers of jury trials won't take us anyplace, but in every case, seeking to do justice will. And I make no bones about it. There are times where plea bargaining is appropriate. When we've had a case where a victim is suicidal on the eve of trial, probably time we should be looking at a plea bargain. If it can recover the body of a small child who was murdered, probably should be looking at a plea bargain. If we can get the defendant to buy into a program, to say, Judge, I agree to do this, and you hold me accountable, we should have a plea bargain. But if someone wants a jury trial, all day long, I love doing jury trials, I will take that person to a jury trial and afford them their constitutional rights. Because what we do is justice, and do it individually, case by case. Thank you. David.
We talk a lot about justice. The truth is, you can't get justice unless you know the truth. And you can't know the truth unless you have the government prove the case. And that's the whole chicken egg problem. How do we know the guy's a sex offender unless we prove it? So what we're saying is we would rather put the thumb screws on somebody rather than prove the case. Now, I have child sodomy case. I don't know what case he's talking about because that violates my plea bargain policy. My plea bargain policy is you plead to the highest charge and you get the consequences if you're going to plead. I took a child sodomy case to trial in December, had the opportunity to plead it out, but didn't, spent a week in trial, got a conviction, he's going to prison for 25 years. This notion that I'm soft on this, it's just an absolute damn lie.
Rebuttal. Do you want Jeff to go first and then rebuttal?
No. Adam.
Yeah, the rebuttal.
Call me a liar? Great. Ask me for the case numbers after the debate. You can look it up yourself and you can see the truth. It's right there, public court records. This is what is going on under the current administration because he doesn't know what's going on under the current administration. Everybody knows this. Defense attorneys are calling me complaining about the good plea deals that they get for their clients because they know that's not keeping us safe. But respectfully, they have to do their job, and I don't fault them for that. I fault where the policies come from. I fault where the vision comes from, and you should too. Thank you.
The notion that the county attorney is not plea bargaining it's just a falsehood. It's happening at the screening stage. He doesn't charge what the evidence supports. He charges something less, and then he says you either plead guilty or we go to trial. Well, the Constitution, let's have a little constitutional instruction here. He's got a fundamental misunderstanding of what the Sixth Amendment provides. The Sixth Amendment guarantees the right to a jury trial, and that's not being denied anyone. If they want to go to trial, they go to trial. Why would we plea bargain? Well, if we have a child sex abuse case and there's 6 counts, 10 counts, or whatever, I'm charging them all. And then we will work it from there. And if that defendant can plead guilty and save that child from having to testify and go through the hell of trial, that is a good outcome. And the plea, by the way, as far as proof, is they take the plea and it's voluntary and knowing.
Time. Rebuttal from Mr. Rebel.
This is just a simple fact, guys. What system you want? The system that the bureaucrats devise where you charge high and get a plea, or where they actually try the case and prove the evidence? Simple question. It's your choice.
Thank you very much. All right. We are coming close on time, and so this will be our final question, and then we will transition into 2-minute closing statements. It's especially pertinent because this is a question on the implementation of Republican principles as Republican elected officials. So, what is the role of an elected Republican county attorney in implementing Republican or conservative policies? Our order is Jeff, Adam, David.
We believe in the Constitution and upholding the Constitution. And we believe in upholding the law, the rule of law. That's my foundation. I love the law and I love the rule of law. And so when I take the oath as county attorney, I take the oath to uphold the law. And my primary responsibility is to prosecute those who break the law. So I am consistent with the Republican Party. That's what the Republican Party wants. The Republican Party wants to hold criminals accountable, and that's what I will do.
Within a county attorney's discretion to enforce policy, a county attorney should enforce the ideals of our Republican platform, the ideals of constitutional order, the ideals of the rule of law, the ideals of life, liberty, and property. Our Republican platform recognizes the central nature of families and the individual in our society. And the county attorney's policies, whether that's at screening or trial or determining charges or anywhere else, has to be focused on upholding those ideals. We hold offenders accountable, we individualize, we be smart about it, so our communities, our families, our children can be safe now and safe for future generations. Thank you.
When you take an oath to be the county attorney, which I have, which I've done 3 times, you swear to uphold the Constitution. And there is no one in any jurisdiction that has more ability to uphold that Constitution with respect to the speedy trial and jury trial than the county attorney. That is a fundamental principle of the Republican Party. Now, you've all heard, or many of you have likely heard of CPAC, the gold standard conservative political action committee in America. CPAC endorses me for re-election. Why? Because I adhere to the absolute certainty that the only way that America will continue to stand is if we return and restore our constitutional principles of the jury trial, which we are losing. We are losing.
All right, thank you. So, we still have a lot of questions here that you guys wrote down, but we're running out of time. So, what we're gonna do is we're gonna move into the closing statement phase, and then what I love about the delegate system is you guys are here, you're super interested, I can tell from your responses, right? Which is fantastic. I'm glad you guys are passionate and you have some opinions and you have some questions that we didn't get to that you want to ask. So I don't know how much time we have in this venue. 5 minutes?
Well, no, until 10 p.m.
Oh, okay. Well, all right. You guys, here's what I'm saying. I'm going to suggest that the candidates stay after a little bit, and then you guys can ask it maybe one-on-one or in groups or whatever, because we told you an hour and we've used our hour. So that's what I'm going to suggest, and I guess we can stay till 10 o'clock.
We're to transition into our closing statements that are 2 minutes each.
I gotta say, that assumes that we don't have, we built this for an hour and I've made commitments with other delegates.
Right.
You can say I'm running away if you'd like to, but the reality is I keep my word and I go where I'm saying to be.
All right. So that's what we'll do, okay? So we're going to give we've said 2 minutes. Do we want to change it to 2.5? You guys want an extra 30 seconds, or you good with 2? 5 minutes? They're attorneys. They'll take the full 5.
Nelson, at your discretion, I suggest you keep it on the shorter side and let the delegates ask us questions after.
Okay. All right. Let's go. 2 minutes. All right. 2 minutes. So, and our order is going to be Adam Pomeroy, Jeff Graves, and then David Levis.
You've heard the debate, you've heard the issues, you heard me get passionate. I believe in this, and I believe we need to do better. We need to hire a new chief prosecutor in our county. And the best thing you can do right now is to hire a current trial prosecutor to do that. I love our constitutional system. I love teaching about it. I love doing it every day. I work with victims. I work with law enforcement. I work with offenders to make all of our lives better. Now, I've used this analogy with some of you. When your child is sick, where do? You go to a pediatrician. You don't go to a heart surgeon. You don't go to a neurologist. You don't go to some guy in the street corner who says good things but doesn't follow through. You go to the person that has the relevant experience. I'm in the office. I've built the relationships. We need to turn this office around. I've worked with law enforcement. We can get there. I know what the victims need because I work with them. I know the opportunities to enact smart on-crime policies to make us better. I've talked about domestic violence specialty courts. I've talked about some amazing programs out there that actually work, and aren't just $5 million thrown at something to see if it works, but there's basis and research and studies. We need to be doing better, and I'm asking you to trust me because I am the best candidate for this job. I have the right experience, and by being here, I know best of all who in the office to trust, who we can put back into the Special Victims Unit and have it done right, who in the office can be our leaders, and simply, who in the office has a good heart and just needs more training, and most importantly, the right vision from on top to get it done right. Thank you.
face an important decision. And I have the commitment to be the county attorney and to uphold the law. And I understand the law. I understand the Constitution. And I understand what our responsibilities are as prosecutors. We have the responsibility to keep us safe in our community, to enforce the law and hold people accountable. What is my experience? I've been a prosecutor for 31 years, 7 years a trial lawyer, what he's reached. But I have 24 years of appellate experience, criminal appeals. Why does that matter? When prosecutors have a question about evidence, what arguments to make, what arguments to defend, what evidence is admissible, do you know who they call? They call me and those on our leadership team in criminal appeals. We are taking those calls and guiding prosecutors all the time. That's what I've been doing. That's the experience that I bring. I bring that experience not of only being a trial lawyer, but I also understand what it takes to make a conviction stick. We need that kind of leadership. We've had cases where the Utah County Attorney's Office, I said, this is bad, don't pursue this. They pursued it and we recently lost on appeal. We need the vision, the broad vision that I bring. I am committed to this, and I'm committed to making this community safe. Thank you.
You guys are kind of a tough crowd. And I'm grateful to be here. And let me tell you why I'm here. I'm not here because I'm trying to get your vote. I'm really not. Why? Because this vote is not going to be decided on the act of April in the county convention. This vote's going to be decided in June among all the Republican voters in Utah County. As it should be, because this is such a significant issue. The issue is, which system do you want of government? Do you want the system these two subscribe to, of just lining people up and processing people and running them through? Or do you want the system designed by the founders, where we actually prove the evidence and demonstrate the evidence and prove the case? Now, the reason why this is going to be decided in June is because I understand that when you hold people accountable that aren't used to being held accountable, they come after you. And that's why the system is coming after me. Not because I'm a horrible guy, but because people don't want change. And they're not bad folks. People just don't like change. But the change that I'm advocating is the change to restore our system back to where it was. And so what did I do? I went and I collected 6,300 signatures to put myself on the primary ballot. And Mr. Gray, I presume he either turned them in today or he'll turn them in on Monday, because he also said that he's going to go to the primary ballot. And if he says he's going to do it, I presume he will. And so I'm here because I'm the county attorney, and I have an obligation as part of my oath to support and sustain and defend the Constitution of the United States. And I'm here to tell you that we're going in the wrong direction if you want to have a constitutional system, because we don't.
All right, we'd like to invite all of our candidates to come up to the front. We are so grateful for this hour-long debate.
Today is National Medal of Honor Day, to honor all of our Medal of Honor recipients. And Jose, who has anyone here ever heard of Jose Valdez? He is Utah County's only Medal of Honor recipient. And he's from Pleasant Grove. Yeah. And so it's kind of fitting that, you know, we have the debate here on the 25th, and I am also the commander of the Veterans of Foreign Wars Post, the Timpanogos Post, and we commissioned a portrait of Jose Valdez, and we've been putting it in schools all over Utah County. And we made a little dog tag of the portrait of Jose Valdez. And I'm going to thank the candidates. I'm going to give each one of them a dog tag of Jose Valdez. And as you go